section.
Thank you. You may be seated. We are here today on our case number 1CACV 150450, Hayward versus Arizona Central Credit Union. Counsel, as you know, each side's allotted 20 minutes for your argument. The appellant may reserve any amount of time you'd like to use in rebuttal. If you do decide to reserve time, though, you're in charge of keeping track of it for yourself because the clock on the podium will reflect the total you have remaining, including what you may have decided to reserve. We record these proceedings, so when you approach the podium, we'd be grateful if you would give us your name and the name of your client. We have read the briefs a long time ago, and again more recently. We've studied the record on the motion to dismiss, and we've also discussed the case in our conference. So with that, sir, you may proceed.
Thank you, Your Honor. May it please the court. I am Hyung Choi, and with me is my partner, Veronica Fabian, and together we represent plaintiff appellant Jamie Hayward. And also in the courtroom, although he's not sitting at the counsel's table, is Brandon Cody from DNA People's Legal Services. And he's here on behalf of MSC, the DNA People's Legal Services, as well as the National Consumer Law Center and the National Association of Consumer Advocates. Your Honors, this case really is all about this.
That's what I can read.
Thank you, Your Honor. This case is all about the contract provision that is set forth in this form board. And this is an exemplar contract, not the exact one. This is the contract that the dealerships use to, it's a retail installment sales contract. And this is in the record as Exhibit A to the first amended complaint. And this provision is prominently on the back side at the very top. Now, this is a contract that my client, Jamie Hayward, signed. And this is a contract that my client made monthly payments under. And this is a contract that the credit union voluntarily agreed to accept assignment of from the dealership. And this is a contract that credit union accepted monthly payments from Jamie Hayward. And the trial court and the credit union wants to rewrite this contract. This contract is plain. It is unambiguous. It says that any holder of this consumer credit contract, which is a credit union, is subject to all claims which the debtor could assert against the seller. So credit union is subject to all claims. That is unambiguous. All claim means contract claims, tort claims, fraud claims, Consumer Fraud Act claims, even the claims that have punitive damages. This contract does not say that the punitive damages are excluded from all claims. This contract does not say attorney's fees are excluded. This contract does not say the costs are excluded.
And the case law around the country is mostly in your favor. There's a few cases going the other way, I understand. But the limiter is shall not exceed amounts paid by the debtor hereunder. I think the record is not clear on what has been paid by the debtor, or what was paid on the note to the Corey, what paid on this note. There's some. I think the language in the complaint is a little bit vague on it. But my question is do we need to resolve whether this clause covers punitive damages and attorney's fees? If we side with you on the order in which the recovery should be allocated?
Well, Your Honor, not at all. If a court sides with us and say that whatever money that recovered from the dealership through the garnishment first could be applied to the punitive damages or anything else of attorney's fees cost, then we are free to pursue credit union for the amount paid under the contract. If the court rules that way, then the court need not decide whether this contract, the first top part of this contract or the first sentence of this contract provision necessarily excludes punitive damages or the attorney's fees or costs. But because the way trial court ruled, and we were not very clear on the exact basis for that, but the trial court said that at any rate, I think at the very last sentence, that the plaintiffs are not entitled to get punitive damages and attorney's fees and the costs from the innocent creditor. We want to address that, Your Honor.
Okay.
And this leads to, despite this clear language, some courts across the country have said that no, in order that all claims does not mean all claims. In cases of affirmative relief where the consumer is seeking affirmative claims against the financial institutions, some cases, starting with the Morgan versus Ford Motor Company out of Massachusetts, says that the breach by the seller has to be so substantial that it must arise to the level of rescission. And some courts have gone with that, and some courts have gone the other way and said, no, all claims means all claims. And in 2012, the Federal Trade Commission came up with an advisory opinion, and I think everybody agrees, everybody here agrees, that the agency, such as the Federal Trade Commission, that came up with its own rules, when they talked about it, that there should be deference paid to it. And they said very clearly that this rule is unambiguous and that plain language should be applied. And also they said if we mean to apply any kind of additional limits, then they would say so. And it remains the Commission's intent that the plain language of the rule should apply. And we think the trial court was wrong to add additional limits to the contract that the parties agreed to. Now, I think that some of the, and I can see where I think the trial court may have felt like it's just not unfair to force the credit union to pay for punitive damages on a conduct that was egregious, that was done by the dealership. And I can somehow see that. But in Arizona, really, we also have another idea of this sanctity of a contract must be upheld. In our Supreme Court said in both Price versus the Hartford Insurance Company, that's from 1975, as well as the State Farm versus Wilson, which is 1989 case, both of them are Supreme Court cases. Those cases concerned whether an insurance company should have to pay for punitive damages incurred by its insured. And in that, the Supreme Court said, if you agree to it, yes, you should be held to it. And this is exactly what happened in this case. Finance institution, the credit union, agreed to it. They should be held to it. And not only that, it's not, and in the brief they said it's just unfair for us to be an insurer or guarantor. But really the amount of exposure for the credit union is limited by the amount that the consumer paid under the contract. So it's not some kind of unlimited exposure. There are two Ohio cases, Regan's and the Hardiman cases. That's sort of on point, but both of cases use the same flawed logic that the Morgan court had, which is to point to some specific isolated languages in the statement of basis and purpose published back in 1975 to add additional requirements to this all claims. And in 1912, the Federal Trade Commission specifically rejected that approach. And that's the same approach that was taken by the Ohio cases. As a matter of fact, the Federal Trade Commission was so clear that there's a case called the Cruz versus Alta Vista Motors. It was cited 4 times by credit union in their responses. It was from Western District of Virginia. And the judge that wrote the Alta Vista case, or the Cruz versus Alta Vista case, which came out before FTC issued its advisory opinion, later on in October of this year, he issued a new decision, and I apologize, we did not cite to this in our brief. It is Hayward versus TMC Enterprises, LLC. 2016 U.S. District Court, Lexus 142928. And in that case, Judge, trying to remember his first name, I know his last name is Moon. Judge Moon specifically reversed himself, and he said the cruise was wrongly decided, and that now with the FTC's own advisory opinion, that there should be no additional limits placed onto this. And that according to the bedrock of a contract interpretation, this should be enforced just the way it is written. And Your Honor, now coming back to the question that you asked, why should trial court apply whatever the amount that we recovered from the dealership through the garnishment first to the compensatory damages? It makes no sense. There's no requirement. We couldn't find any case law that says it has to first go to the compensatory damages. It could just as well apply proportionately to all three claims that we have for punitive damages. I'm sorry, actually four. Compensatory damages, attorney's fees, and the cost. This 29% is what we recovered so far without counting the interest.
Is that what it is? 29% of
the total judgment amount.
Of the judgment?
Yes. It was recovered through the garnishment. And it just does not make any sense to first apply that to the compensatory damages.
Well, and while I'm sure the jury verdict broke it down into categories of damages, does your judgment even set forth these different elements?
Yes, that's correct. The judgment lists the compensatory damages, punitive damages, attorney's fees, and the cost separately.
I mean, I think a judgment is just an effectual determination that you're owed a certain amount of money.
And so there's really no reason to separate them out and first apply it to the compensatory damages only. As a lawyer, I would say, my client incurred all these attorney's fees in order to get that judgment. So I would think the attorney's fees should be covered first. But that's from my perspective. There's really, and not only that, in Arizona, the ARS-12-3041.01, under which the attorney's fees were awarded, is more of a compensatory in nature anyways. The statute specifically says that attorney's fees should be awarded to mitigate the burden of establishing just claim. So it's more of a compensatory nature. Last, the trial court also was wrong because the trial court was confused about the limit on the recovery from the credit union as opposed to how much we can get from the car dealership. So the car dealership took the money we recovered from the trial court took the money we recovered from the car dealership and applied it towards the limit on the recovery from the credit union. Trial court was confused. For those reasons, we asked the court to reverse the trial court and hold the contract should be written the way it is enforced, or enforced the way it is written, and also hold that the trial court was wrong to apply the recovered amounts to the compensatory damages only. Thank you. And I will reserve my time.
Okay, thank you. Thank you. Okay.
Good morning, Your Honors. Matt Kleiner on behalf of the appellee, Arizona Central Credit Union. I'd like to start our discussion here today with a discussion of the purpose of the holder rule and to help in assisting us understand why the trial court correctly granted the appellee's motion to dismiss. The holder rule was designed to remedy a situation where the lender's right to payment had been divorced from the seller's obligation to provide the goods. This created two separate and independent obligations. The lender, as a holder in due course, was able to enforce its rights against the consumer, regardless of whether or not the consumer actually obtained what they bargained for in the deal. But the consumer, on the other hand, had no ability whatsoever to seek a refund of the monies paid to the lender. to stop payment to the lender or to otherwise unwind the transaction if again, they didn't get what they had bargained for. The holder rule essentially remarried these two independent obligations and gave the consumer both a shield and a small sword with which to defend claims that are brought by the lender for payment, as well as to affirmatively assert claims against the lender for derivative liability. And as to the affirmative claims that are being brought and going to the 2012 letter, there is no dispute that the consumer has the ability to bring an affirmative claim regardless of whether or not there's a rescission or restitution claim. That's what the whole purpose of the 2012 letter was, to say that you don't need restitution or rescission to bring an affirmative claim, and we agree with that.
Meaning Ms. Hayward would not have to return the car. Is that what?
Right.
Is that the point on?
The point is there was a whole series of cases that the 2012 letter was designed to address, and in those cases, the court held, in the cases that the 2012 letter distinguished, the court held if you are going to bring an affirmative claim without a companion rescission or restitution claim, then you won't be able to do that under the holder rule. But the 2012 letter said, no, you don't need restitution or rescission in order to do that. And that was the extent of it. So it didn't go on to talk about claims and defenses or anything like that. It was all affirmative claims can be brought against the holder. But the holder rule is not unlimited. And as Your Honor pointed out, there's a provision at the bottom of the contract that says the consumer's recovery in an affirmative action against the lender is limited to the return of the monies paid under the contract. So the holder rule effectively allows the consumer to bring the creditor to the table in the event that the seller's conduct caused damage and the consumer was otherwise unable to recover that damage from the seller. And this provided the consumer with recourse that had not been previously available and allowed the consumer to unwind a transaction and to be compensated through a refund of monies paid under the contract.
It doesn't say monies paid. It says amounts paid.
Correct.
I just checked. I'm just looking at it. I couldn't remember either. What does that mean?
So
Amounts paid by the debtor hereunder.
that specifically means that the creditor's liability with respect to any claims and defenses that may be brought by the consumer are limited to repayment of the amounts paid under the terms of the contract.
Does that include, for example, the value of a trade-in?
Yes, Your Honor.
So the value of the trade-in car plus the monthly payments made? Is that and
Correct.
the down okay.
Yes, all the monies that we're going into the contract to become part of the compensation that goes to purchasing the car.
Would it be the net value of the trade-in? Or in a case like this, the whole amount, the whole value of the car? Or is that to be determined?
I think that would ultimately be determined as to what the value is of the car and the trade-in value of it. So going to the purpose of the holder rule, if we apply the purpose to the rule and to the facts presented in this particular case, the trier of fact, based on the judgment that was presented and the jury ultimately concluded that the consumer was entitled to $17,000 in damages, and that's what the judgment specifically says, in compensatory damages. It also awarded punitive damages, attorney's fees, and costs. Now, had the dealership not been able to pay the compensatory damages award, then the holder rule steps in and says the credit union is going to be obligated to pay those funds because those are funds that could be earmarked for payments that were made, a return of payments that were made or amounts that were paid under the terms of the contract.
Well, I'm probably jumping ahead of me, but I'm going to follow up on what Judge Thompson asked you earlier, and that is the notion that a judgment is fungible. It's just money. And is there anything that would, any statute or rule or case or anything that would indicate when you're paying on a judgment, you pay one part of the judgment first?
The concept of when you bring a lawsuit is to be compensated and to be made whole for your damages. And that was Ms. Hayward's goal in pursuing the litigation against the dealership, was to be made whole for their damages. The jury, upon reviewing all the facts, concluded that yes, she was damaged and was entitled to compensation for that damage. Under the principle of trying to make her whole, any monies received first should be applied to making the consumer whole. In terms of a case, responding to your question,
Case, statute, rule, anything.
there is no case that I was able to locate in Arizona on this issue. If you look at,
Is there anything anywhere?
it's really an undecided issue, and it goes into ultimately the kind of the public policy behind this, and so punitive damages can't even be awarded unless you have an award of compensatory damage. So logically, it follows that any payment of compensatory damages should first be paid before you get to the punitive damages. When you go to the limitations of the holder rule, the limitation, again, was not designed to act as a weapon to exact punitive damages from a non-culpable lender, and it was not designed to punish the lender. Again, its purpose was to make the consumer whole, to return the monies that had been paid back to the consumer. This is why punitive damages, fees, and costs are not covered by the holder rule, because these, unlike compensatory damages, aren't designed to return monies paid to the consumer. The purpose of these damages are to penalize the seller who acted outrageously in having one of their employees steal a car and then decide that they're not going to fulfill their end of the bargain when they had promised to pay off that loan.
But I mean, I take what you're saying about why the holder should not be liable for punitive damages, and this is an egregious case. But on the other hand, why should the holder of the note get to pick, really, how the garnished amounts should be allocated? I mean, if we're talking about public policy, why do we allow the holder to get the benefit of the fact that Ms. Hayward recovered on the garnishment before she turned around and sued the holder?
The credit union is derivatively liable for the seller's conduct. And so in this situation, the creditor necessarily is also going to be derivatively going to get the benefit for any payments that are made by the credit union, or by the dealership. You can't have a situation where you have this derivative liability, almost a fund, or treating it like as an insurance or as a guarantee, because if you allow the plaintiff to pick in this particular instance and start applying it to punitive damages or fees and cost, you're not making the plaintiff whole. And that's the objective of this litigation, is to make her whole.
Well, that's not the argument you want to make, is it? She's not going to be whole if she recovers from the credit union. Anyway, is she?
According to the jury that ultimately rendered the judgment, the total amount of her compensatory damages was $17,000. The seller, the dealership here, paid $23,000. So when you look at the amount that she was damaged, as determined by the jury,
You're talking about, okay, I take that.
So,
But this wouldn't be an argument that would be available to the credit union, would it, if rather than pursue garnishment of the dealership, Ms. Hayward had taken the judgment and sued the credit union?
Your Honor, I saw that argument in their brief, and the practicalness, or when you apply that argument into practice, what happens is that if they had sued the credit union first, because the credit union is only derivatively liable or responsible for the tortious conduct of the seller, the first thing that the credit union is going to do is to tender their defense to the seller. If the seller refuses, the second thing that they're going to do is they're going to cross-claim against the seller. So the seller is going to be in that litigation and answering for their bad conduct, and presumably the first dollar that the seller pays is going to be then offset by any responsibility for the holder. And kind of going back to the big picture in terms of what the holder rule, what the purpose of it ultimately is for, is to create the situation where the consumer does have recourse to get its money back, or to get her money back in these types of transactions. It's not designed to create a fund by which punitive damages can be be paid. And if you allow the first dollars that come in on payment of a judgment to apply towards punitive damages, essentially you're treating the fund as backup for punitive damages. And so all this money will come in for punitive damages to be paid, and then the last dollars will then be allocated to the compensatory damages. And so that's something where the holder rule is then creating an insurance or a guarantee of payment, which again wasn't the intention of the holder rule.
You know, the question I asked before, actually, maybe I didn't make it clear in the who sues whom first hypothetical. Assuming Ms. Hayward sued the dealership as she did, got a judgment against the dealership, by then the dealership is out of business, rather than pursue the expensive remedy of garnishment, at that point she turns to file a claim against the credit union. So assumedly she had recovered nothing on her judgment. In that event, wouldn't the credit union be liable first dollar? Up to the amounts paid here under?
And I would argue that would be the very purpose of the holder rule. So if the consumer is unable to recover the funds from the seller, then the credit union steps up and says, we have these funds that are available, and is really responsible for them up to the amounts paid under the contract. And when you look at kind of fundamental fairness of how this whole process works, this issue isn't with the application of the holder rule. It's ultimately with bankruptcy. And so what happens here is the seller did pay $23,000, and you know, the realities of litigation, the fact that they got $23,000 from the seller is good.
Remarkable.
You know, it could have easily worked out the other way. They got no money from the seller, and instead of getting the $23,000, the seller files bankruptcy immediately. But that's why you have the holder rule. The holder rule steps in and says there's another party that can be responsible for the amounts paid in under the contract, and that's how the process worked and what it was designed for. Again, it wasn't designed for the holder to be responsible for punishing the seller. That responsibility should be borne only by the seller.
Maybe this is a dumb question, but what happens to the note in this circumstance? Is the note void because of the seller's behavior, or what happens to the note?
In this context, the note has been paid, and that's the allegation. So the note has been paid. The seller has their car plus the $23,000 that they received from the dealership.
Has the buyer paid the note?
Has the buyer?
That's your question.
Yeah.
Whether there's an ongoing monthly obligation since she's holding onto the car.
I believe that the buyer, at least what was alleged and stated in the briefs, I don't believe this is actually a fact that had been determined yet, but I believe that the buyer claimed that they had paid the entire amount of the note as of the time of this litigation.
Okay. We'll hear if that's not the case, I'm sure.
Yep. And they can correct me if I'm wrong, but I believe that was my understanding of the briefs.
But if the note had not been paid, the credit union would be prevented from suing on the note by this holder rule, right? I mean, the debtor would say, I don't owe you the money on the note because the seller of the car did all these things to me. Isn't that how it would work in another case?
In another case, but then you also have to take into consideration, does she still have the car? So the compensatory damages that were awarded presumably went towards paying off the value of the trade-in.
Yes.
So she gets that money back, and then the money in terms of the purchase of her new car is still owed. And so that's kind of one of the reasons we threw in the question about the offset at the end of our brief, is that there is a question as to whether or not the funds that she is getting, or the benefit that she is getting from using the car for the 4 months, should be offset against any amounts that would be owed by the credit union. And I'd like to touch briefly on kind of the concept, too, of punitive damages, and the arguments were raised in the brief that punitive damages with respect to these cases in Ohio were different because of the nature of the statutes there. And the comparison was made to, well, Arizona does allow for punitive damages in certain circumstances, for example, in a partnership context or an employee-employer context. And if you look at the partnership context, the Arizona legislature adopted the Uniform Partnership Act, which provides that partners are responsible for each other's acts. And in the language of the Uniform Partnership Act, it specifically says, including any penalties. So the legislature thought to put into the statute that partners are specifically responsible for each other's penalties, aka the punitive damages. In the employment context, similarly, the employer has direct control over its employee, and the employee has to be acting within course and scope of its business in order to get an award of punitive damages against the employer. The situation here is simply can't be compared to a kind of a respondent superior situation. You have two different businesses, two fundamentally different businesses. One's a car dealership in the business of selling cars, and you have a bank, a lender in the business of lending business. You can't have the credit union weighing in on the hiring and firing practices of a car dealership, and to make sure that those employees aren't stealing cars. And because of that, we're getting to a situation where we're not dealing with respondent superior. It's not a punitive damage type situation.
But there are ways of allocating the risk for example, in the amounts paid. When the creditor buys the note over the big scheme of things, you can imagine a different allocation.
Are you going back to the question about which dollar goes to
No,
which?
no. I'm sorry. What I'm speaking of is, to be sure, the creditor is not the insurer of the dealership. On the other hand, if you look at the nationwide market to which the holder rule applies, you can imagine a scenario where creditors would say, we're getting held up here because there are too many claims filed against the dealer. Therefore, we're not going to pay you as much for the notes if the holder rule is going to be interpreted in a particular way. If we're taking on that risk, we're not going to pay so much for those contracts. So you can imagine a scenario where as in the marketplace.
And I agree, and that's goes to the underlying principles for the holder rule. But when you're dealing with a situation like we have here, you have, like you said, it's an egregious situation where you have an employee who comes in, steals a car, the dealership refuses to pay on it. This is unique, and if a credit union, a bank, is required to assume that in every contract an employee is stealing a car and this is happening, and that they're going to be liable for punitive damages up to 3, 4, 5 times the amount of the actual contract, that means that in every contract they're going to lose all of their money, and they have to assume that's going to happen. So then you're getting into a situation where they're going to have to increase the cost gets passed down to the consumer, and it can snowball. And ultimately, I think you're going to see a situation where these indirect lenders, which is what the holder rule governs, will start becoming just direct lenders. And then you've basically circumvented the whole purpose of the holder rule by allowing the lenders to just go a completely different route. So to your point, yes, you have to be able to look at the dealerships and the natures of their business, and the lenders have to be able to make a determination. And that's why the holder rule was inputted.
It's interesting that the holder rule is both in the federal reg and in the contract. I presume it's in the contract because the federal reg requires it.
And it would be read into the contract.
And so that's why the cases nationwide, both in federal and state courts, inform us as to what the meaning of this particular contract term means. Right?
Correct.
Okay.
Correct. And just to wrap up in the last few seconds that I have, ultimately, since compensatory damages represent the only potential claim by which the seller can obtain a refund of the monies paid as opposed to a penalty, the holder rule does not require the credit union to pay the penalty, the punitive damages, fees, and costs. These are not payments that were made under the contract to which Ms. Hayward would be entitled to. And for these reasons, the trial court correctly granted the credit union's motion to dismiss. And unless the court has any further questions, we'll submit and look forward to your decision.
Thank you.
Thank you, Your Honors.
Your Honor, you asked a question regarding whether this is a part of the contract that is mandated by federal regulation. That is correct. And different states have different rules on how the contract terms should be interpreted. In Arizona, we have Maxwell versus Fidelity Financial Services, where the Supreme Court said that this is a part of the contract, and as such, it should be interpreted as a contract. In addition, in Arizona law, if the contract term is unambiguous, then there's no reason to look behind the unambiguous terms of the contract to look for the intent purposes. And we submit to you that the way this contract is written, it does not say punitive damages should be excluded from all claims. Now, even if we look beyond that and we go into the purposes, again, I refer the court back to the FTC's advisory opinion that came out in 2012. There are two purposes behind the holder liability rule. One is to shift the cost of a seller's misconduct from the buyer, the consumer, to the financial institution. The second purpose is, says right here, that a strong potential consumer remedy will encourage greater policing of merchants by financial institutions. So by requiring this kind of a contract provision, the FTC wanted financial institutions to better police the dealers. And it makes sense because financial institutions can set the price, they can set the interest, and they have all the control, and they can better police the financial institutions. And that goes to really beyond what Arizona has talked about in punitive damages. In Arizona, punitive damages serve two purposes: to punish and to deter. And by subjecting the financial institutions to punitive damages, and it's not, again, unlimited amount, it's only up to the amount paid under the contract, that it would provide deterrence to dealerships who wants to continue to sell their contracts to the financial institutions from engaging in such a bad behavior. We think that the market mechanism will be better enforced by just enforcing the contract as it is written. Now, counsel for the credit union continue to say that just by having compensatory damages paid, that Jamie Hayward was made whole. That just completely ignores reality. In order to get that jury verdict, she had to go through 4 days of jury trial, 2 years of litigation. Yes, the attorney's fees awarded pursuant to the ARS 12-3041.01 was only for $10,000. But the realities are she incurred much, much more than that in her attorney's fees. And because the claim was separated between the breach of contract claim, where you can get an award of attorney's fees, and the fraud claim, where you couldn't get attorney's fees, the judge made a determination. But to get to that point and to garnish those money, she had to incur tens of thousands of dollars in attorney's fees. She has not been made whole. Nobody's been made whole. The only people that's been made whole so far is the credit union. And let's also talk about, and I think that I have a sense the court fears that the trial court just applying the money recovered first to the compensatory damages was wrong. In Arizona, there's a doctrine called an equitable doctrine of marshaling. And that's where if you have two creditors, that one creditor with a senior interest cannot go after a certain amount of money to basically leave out the second creditor in the court. I understand this is not exactly that situation. This is one where we have a multiple claims with multiple amounts. But the concept is the same. You should try to apply money available to places where the creditor can be made whole. And in this case, by applying money first to the compensatory damages, Jamie was not made whole, not even close. Really, the case that we really did not cite, unfortunately, and I'd like the court to focus in on is the State Farm versus Wilson. That's 1989 case where our Supreme Court considered whether State Farm should be liable for punitive damages under a underinsured motorist claim. And in that case, the court first found that there was an ambiguity in the contract. The ambiguity was between the provision that says the State Farm will pay for all damages arising out of bodily injury. And then compare that to another provision of an insurance contract where it says that we will pay for all damages the insured can collect from the tortfeasor. So in that case, the court weighed and said, well, we think that insurance policies should not cover that because of different policy reasons. But the court found the ambiguity first. If the insurance contract just already said was we will pay for all damages the insured can collect from the tortfeasor, there would not be an ambiguity. And the Supreme Court would not have any problem ordering State Farm to pay for the punitive damages. That's because the State Farm agreed to it. And in this case, the credit union agreed to pay for all claims, which is very similar to the language State Farm used in the Wilson case. We asked the court to reverse trial court based on the contract and enforce the contract as written. Thank you very much.
Thank you. Thank you to both sets of lawyers. We're grateful for your briefing and your argument. We'll take the matter under advisement and we'll issue a decision in due course. Now we stand adjourned.